Good evening, everybody. My name is Rosalind Dixon. On behalf of CCCS at Melbourne Law School and the Gilbert and Tobin Centre of Public Law, I wanted to welcome you to this special Global Public Law series. This evening, we will be talking about Australian electoral laws, constitutional and policy questions in light of some very significant recent legislative change and proposed change around Australia. I want to begin by acknowledging that we're all coming to this special seminar from diverse Aboriginal lands. Here in Sydney, I am on Gadigal land and want to pay respect to elders past, present and emerging, and encourage you to, in the appropriate way, acknowledge the land that you are joining this meeting from. As you will see, this is a live webinar, but it's also recorded. We're very lucky to have an absolutely star-studded lineup this evening of experts on political expression and campaign finance. Our first speaker this evening will be Dr. Catherine Williams, who's Executive Director at the Centre for Public Integrity, an institution that works very closely on these issues and a range of other important public law questions. Catherine's research focuses on enhancing transparency and accountability in a whole range of settings involving the exercise of public power. And she's the co-author of an important book called Keeping Them Honest, The Case for a Genuine National Integrity Commission. And of course, the book is had the greatest mark of success in terms of the changes in that area. Our second speaker, it needs no introduction to this audience, as the CCCS eminent Melbourne Laureate Professor and Director of the Centre, Adrienne Stone. Adrienne researches in a range of areas in constitutional law and constitutional theory, but is arguably Australia's leading scholar of freedom of expression and academic freedom, along with her co-author, Carolyn Evans, on the topic. She wrote a very well regarded and extremely illuminating book, Open Minds, Academic Freedom and Freedom of Speech, 2021. For those of you with a more academic bent, you'll also know that Adrienne, along with her colleague Lulu Weiss, is the foundation editor of Comparative Constitutional Studies, an important new journal coming out of Melbourne, and is immediate past president of the International Association of Constitutional Law. Adrienne is joined by her co-director, but before I introduce Will, I want to introduce Associate Professor Nwokora, who is a Associate Professor in Politics and Policy at Deakin University, where for his sins he currently serves as Associate Head of School. More happily, leads international engagement for the school and works across a range of topics. But his particular expertise tonight that we're calling upon is his recent research on constitutions, political parties and campaign finance as it's embodied in a very newly published, co-edited and co-authored volume with Matteo Benotti entitled Money, Parties and Democracy, Political Finance Between Fat Cats and Big Government. And Zim will be bringing that comparative theoretical perspective to our discussion this evening. Last but certainly not least, Associate Professor William Partlett is, as I mentioned, co-director of the CCCS and Stephen Charles Fellow of the Centre for Public Integrity, so brings the full circle in terms of the CCS public integrity perspective on this topic. Will writes and teaches in the field of public law. His research is wide-ranging in Australia and elsewhere, being the author of a recent important book on Russian constitutionalism, but of course we're hoping not to follow down Russia's path this evening, so we'll be focusing more on his work on Australia and on constitutional structure in ensuring democratic governance. So thank you all so much for joining us. I'll remind you that there are a number of pieces of legislation and potential legislation in this area of discourse, but there is particularly important changes in the Commonwealth and in Victoria, which our speakers will be talking about. And we're very delighted that we have a range of Victorian and national attendees and that you can all join us this evening. But if you can start us off, Catherine, by just giving us the lie of the land in terms of where does this reform come from, what is its broad terrain and contours, and what do we need to know about the specifics of the legislation?
Wonderful. Thanks so much, Ros, and thank you to everyone for making time tonight to join this conversation. The Centre for Public Integrity, the organisation I lead, has for a long period of time now been involved in electoral reform processes at both state and federal level because we have a strong research focus and advocacy focus on how to achieve the elimination of undue influence of money from politics and creating a level playing field. Our position is that key to this is achieving transparency of political donations and also the adoption of appropriately designed donations and expenditure caps. And therein lies the diabolical complexity of this kind of reform, electoral reform, because if the caps are not appropriately designed and do not properly account for the real advantages of incumbency and major party membership, we risk some seriously undesirable outcomes. So I'll start by talking through some of the key pieces of the recently passed federal electoral reforms from an integrity perspective, talking about why they are justified and what the problems that we could already see might be, and talking about some comparison with jurisdictions where similar and also different measures exist. So we've seen recently the introduction at the federal level of significant political finance reform. We've seen the bringing in of a lowered donations threshold, the broadening of the definition of donation, the introduction of donations caps, expenditure caps, as well as changes to public funding arrangements. So these are the really key integrity-focused changes in that political finance legislation. So first, on the issue of disclosure of donations, we've seen a significant lowering federally of the donation disclosure threshold. It will now sit at $5,000. Now, bearing in mind that's $5,000 to each separate branch of a party with that is a national party with state, territory, federal branches. And already here we start to see the failures of the federal legislation creeping in. But still, this is an improvement on the almost $17,000 that can currently be donated without disclosure to each branch. This change is important not only from a transparency perspective, but also because it brings the Commonwealth more into line with the thresholds for disclosure that are set by the states and territories. So we've got these thresholds much lower, I mean, lower than the even reduced federal disclosure threshold. So we're talking about $1,000 in New South Wales and Queensland and the ACT, marginally higher in Victoria, where the threshold is indexed annually, which I think is actually an important feature of the Victorian regime. Slightly higher again in the Northern Territory and Western Australia, and then a bit higher again in South Australia. The fact that we've seen the Commonwealth's position move from being such a significant outlier to much closer to the states and territories is going to make it harder for donors to circumvent one jurisdiction's laws by making donations to a party branch in a less restrictive jurisdiction. So, for example, a Victorian donor wishing to donate a substantial amount to their preferred political party but maintain their anonymity could previously have simply donated any amount up to the high federal threshold into the federal account of their preferred party's Victorian branch, thereby avoid the Victorian donation disclosure requirements. That will be harder now, and that's an important thing. The federal bill also provides for real-time disclosure of these now reduced donations. And these provisions are, in my view, some of the best provisions in that federal bill. So we're now going to have a system where donations are disclosed in a much more timely fashion, especially as we get closer to elections. And this is really good news because in the current system, up to 20 months can elapse between the making of a donation into the federal system and it becoming public knowledge. And voters obviously need to have access to information about who's been donating to whom and when to be able to exercise their votes in an informed way. So to move from the issue of better transparency of donations via reduced donations disclosure thresholds and real-time donation disclosure and more into the complex area of donations caps. Caps, our position at the Centre for Public Integrity is that caps, when part of an appropriately designed political finance regime, are important because in their absence, well-resourced individuals and entities have an opportunity to buy, as it were, undue influence and access. The public is, of course, aware of this risk, and as a consequence, the absence of restrictions on the size of donations has a harmful impact upon fraying public trust. Public trust in democracy requires that impartiality in government decision-making not only exist, but be seen to exist. The High Court has, of course, recognised previously the utility of donations limitations. It held, as probably many of you here are well aware, in 2015 in its McCloy decision, that the risk to equal participation posed by the uncontrolled use of wealth may warrant legislative action to ensure or even enhance the practical enjoyment of popular sovereignty. That judgment, so it was the judgment that was, of course, upholding the constitutionality of New South Wales laws imposing caps on political donations and banning donations by property developers, specifically recognised that the donations caps in question did not impede the system of representative government provided for by our Constitution, but preserved and enhanced it. Now, again, I caution that while the Centre for Public Integrity is supportive of donations caps, that is dependent upon it being part of an appropriately designed regime. And we have examples of inappropriately designed regimes. One we see in Victoria, where we have donations caps that exist, but we have no expenditure caps, and we have a nominated entity exemption. And the combination of those things produces, I think, serious inequity. And currently, of course, we've got the nominated entity exemption being challenged in the High Court, and we watch with great interest how that is evolving. Federally, the legislation in respect of donations caps is also deeply problematic because it fails to aggregate donations to different party branches for the purposes of the $50,000 gift cap. It also fails to aggregate donations for the purpose of disclosure too. But the failure to aggregate donations for the purposes of the donations caps means that wealthy interests will be able to continue to access the political process in a way the average Australian can't, and it's seriously inequitable. To move on to another major change in the new Commonwealth legislation, expenditure caps. For a variety of reasons, our position is that we do need restrictions on electoral expenditure. Uncapped, unequal, excessive electoral expenditure does have implications for political equality, as well as for fundraising, decision-making and resourcing. And we really want to see our elected representatives be able to focus on their functions as elected representatives, their scrutiny functions, their constituent representative functions, where they are ministers and ministerial responsibilities, rather than on raising funds for the next campaign. But again, and at risk of sounding repetitive now, I emphasise that caps only have a place in an appropriately designed political finance system. So, for example, we see in the New South Wales model that independent candidates have a proportionally higher spend than endorsed candidates and parties to account for the positive externalities of general party advertising. That is not a feature of the new federal regime and is really, I think it's inevitable that it will now be harder for non-party candidates to compete. Another really significant flaw in the federal regime is the national cap of $90 million that's available to parties only, and there's no provision to prevent them from using that money to flood key races. This cap will do nothing to alleviate the arms race for funding, which is really, really unfortunate, particularly because that sort of outcome was used to justify the passage of these federal reforms. We see too in the federal regime the inclusion of that nominated entity exemption that originated in Victoria, has now appeared in South Australia, and now we see it at the federal level, which means that some associated entities can receive special treatment by virtue of being named as nominated entities, and that parties with substantial assets can spend vastly more than other competitors. Nominated entities should be able to spend and donate just like any other associated entity, but they should not be exempt from the limitations applying to those other entities. Now, I don't want to talk much on the final issue of public funding because I know that Zim is going to talk about this later on. Just in short, from an integrity perspective, I note that our system of public funding, our federal system, our state and territory systems are not working as they should. Public funding is fraught with risks. We know that it can fuel excessive electoral expenditure, sap the internal vitality of parties, entrench incumbents also. And what we've seen pass federally now is change to the public funding arrangements, including the introduction of significant administrative funding. So I'll leave this, of course, to Zim to unpack, but just flag it as another seriously problematic aspect of the federal reforms. So as will be clear from the long list of reforms that I've sped through, we are talking about reforms where no one in the parliament could be said to not have a conflict of interest arising when they're dealing with it and voting on it. These reforms affect how much candidates and incumbents can raise, how much they can spend, and this, of course, influences their chances of electoral success. So we have to look very carefully at the processes surrounding the passage of reforms of this nature. Last year in South Australia, the Malinowskis government passed its proposed political reform, for finance reforms, only after a period of significant expert consultation, including the obtaining of an independent expert report. This saw the original proposal shift markedly, and ultimately it passed with broad support of the Parliament. The federal legislation, on the other hand, was passed without a proper consultation process, without an inquiry process, and with only the support of the major parties. And in fact, our board issued a statement calling the process an affront to the democratic process because of the absence of genuine consultation or an inquiry and the hasty passage which included the guillotining of debate. We also don't see in the new federal legislation a mandatory statutory review clause. We advocated strongly but unsuccessfully for this. And one of the reasons we advocated for it so strongly was because we had seen in Victoria that a robust clause, as the Victorian legislation has, could result in a really rigorous report making public the consequences of this state's 2018 donations reform. That transparency is essential to political accountability, and alas, it's not provided for in the federal legislation. We must all be concerned, alarmed really, when legislation as foundational to our democracy as electoral reform is passed in a way that most recent federal bill was. And where we go from now, I will leave to my colleagues to discuss further. Thanks very much.
Kevin, do you want to just clarify for people who are less familiar with the events, just the nature of that guillotining, but how the debate ended up, just when you say it was passed in that manner, just to give us an additional 60 seconds on that context?
Sure. So the bill was originally introduced late last year, and it was a significant, very, very complex, large piece of legislation that was dropped, and passage was sought very quickly. That was not able to happen late last year. And I think, if I recollect properly, the Special Minister of State indicated that he would seek to negotiate the passage of that legislation again over the summer. That led to the legislation being reintroduced in the early days of this year, where it passed from its reintroduction to passage. It may have, and I would have to go back and check, Ros, but it was 1 or 2 days that it was back in front of the Parliament for. Again, we're talking about really seriously complex legislation, and it should have had proper time to be debated, for people's concerns to be able to be worked through, aside from the fact that it should have had a parliamentary inquiry process, or at a minimum an independent expert review process take place so that parliamentarians could see if there was any evidence to justify the settings that had been selected in the legislation, because we know the settings are critically important. You get the settings wrong and you risk producing really serious distortions.
Thanks so much, Catherine. Now, Adrienne, over to you. I know you're going to focus mainly on the Commonwealth legislation and the issues of constitutionality that these reforms might be said to raise.
Great. Thank you very much, Ros. And let me start by acknowledging that I'm speaking to you from Wurundjeri land on which I live and work. And I also want to acknowledge the support of the Electoral Regulation Network at Melbourne Law School for this seminar. And we're delighted that the Centre, CCCS, has been able to work in partnership with them as well as the Gilbert and Tobin Centre to bring this event to you. I am going to focus on the Federal Act, the 2025 Federal Act. That's the Electoral Legislation Amendment, Electoral Reform Act of 2025, because there's much happening in this area at the moment across Australian law that I think we can really only get a sense in a short time of just one. But there are provisions in this Act that mirror, have been picked up from other acts, and so I think that there will be relevance well beyond just the Federal Act in what I've got to say. I'm going to offer commentary on where I think the Act might be most vulnerable to constitutional challenge, but of course, without attempting in this time and in this format to be either fully comprehensive or definitive about that question. So let me just say something about what the core provisions of the Commonwealth Act are, or the new Commonwealth laws are. So the bulk of the Commonwealth laws will come into force on the 1st of July in 2026. What it's aiming to do, apparently, is to bring greater transparency and fairer competition in political campaigning. And among other things, what it does is, as Catherine has says, is it lowers the disclosure threshold, it increases disclosure speed, it caps donations and expenditure. And that's really where I want to focus my remarks tonight. And there are some public funding provisions as well. Before I go into that, I thought it would be useful just to review in a very skeletal form what the basis of any constitutional challenge would be. Constitutional questions arising in relation to this legislation would, of course, be grounded in Sections 7 and 24 of the Constitution, which provide that the Houses of Parliament are to be directly chosen by the people. That in turn gives rise to a freedom of political communication, a doctrine that the High Court describes as implied from constitutional text and structure. Now, the essential question that these new provisions pose is whether they place an unjustifiable burden on political communication so that they interfere with this underlying requirement that the Houses of Parliament be directly chosen by the people. That, in outline, is the question. To give just a little more doctrinal detail, in any challenge, a court, including the High Court, would step itself through a number of questions to determine the fate of any challenge. It would ask itself whether the challenge law burdens political communication. It would then, assuming the answer was yes, turn to consider the following the question. First, does the law have a legitimate purpose or purposes? And if so, is the law reasonably appropriate and adapted to advancing that legitimate purpose? And at this point, just to get into a little bit of technical constitutional law, the court would step itself through a 3-step process known as structured proportionality testing, where it would really be concerned to identify whether the law has a rational connection to its purpose. It would be looking to see if there were obvious or compelling alternative or reasonably practical other means that it could get to the same end without burdening political communication so much. And then there's a final criterion which enables the court, if it wants to engage in a value judgment about whether the burden on political communication is worth it in light of the importance of the end. So essentially what we have is a test of means and ends. Is the law pursuing an end that the court considers legitimate, and is it doing it in a way that is reasonable having regard to those matters I've just mentioned? Now, we do have some past cases that will be relevant, and of course here the interaction between the Constitution and electoral funding laws is long-standing. In fact, it dates back to the High Court's very first case recognising a freedom of political communication in 1992, when in a case called Australian Capital Television, the High Court struck down a Commonwealth law prohibiting electronic advertising during election periods. And then there was a very considerable break when there were no electoral funding cases that came before the High Court until the mid-2010s, when there were a series of cases that arose out of New South Wales legislation that gave us some more insight into how the court will consider laws in this area. And the two most important were the Unions of New South Wales case in 2013 and McCloy in New South Wales in 2015. In the first case, the court heard a challenge to two sections of a New South Wales law and struck them down. And in the second, it heard further challenges to the same law and upheld them. And I'll say something more about those in due course. Now, despite the different outcomes, and there are some other cases around which I won't say too much about, I think there are a number of principles that can be fairly stated. So, first of all, the effect of restriction on funding in schemes of this kind, which involve donation and expenditure caps, has been recognised by the court to constitute a burden on political communication. So laws that affect a restriction on funds available to political parties and to candidates to meet the costs of a political communication by restricting the sources of those funds, those are burdens on political communication. And it seems to me that that's what we have here in the Federal Act. And in particular, it's important, I think, to note in Unions of New South Wales that the court found that the burden imposed isn't vitiated by the provision of public funding for electoral campaigns, because parties are always going to want to spend more than the publicly funded amount, and so the parties need to find a way to fund the gap between public funding and the full costs of their campaign. Now, I raise that because one aspect of the federal law that I haven't touched on much is, in fact, to increase available public funding. And so I just note that I don't think that that will vitiate any argument that this Act does constitute a burden on freedom of political communication. All right. The second really important principle I think comes out of it is that a scheme of expenditure and donation caps can be seen to pursue a legitimate end. And that legitimate end, that purpose, is the prevention of corruption and undue influence on the political process, or the appearance of corruption or undue influence. Now, as the court says, particularly vividly, I think, in Unions of New South Wales, a law that's directed to that purpose is not just compatible with the requirements of Sections 7 and 24, it's actually seeking to further the same kinds of ends that those sections are there to do. They will ensure that we have elections where people are able to make a choice for their representatives that is a true choice. Okay, so I think there's a burden on political communication. I think it's likely that so far as the law can be characterised as directed towards preventing corruption and undue influence and the appearance thereof, that we also have a legitimate end. So for this reason, I think it's likely that the expenditure and donation scheme in the new federal law, any challenge to it will end up turning on the third part of that legal test that I outlined. And that is, the real question will be whether this law is reasonably appropriate and adapted to a legitimate end using those three stages of proportionality analysis that I spoke about. Now, perhaps to your relief, I am not going to tail in detail through each of them, as I might do in a 2-hour-long constitutional law class at the University of Melbourne, but I do want to say the following. A defining teaching feature of this test is that it is flexible and context sensitive. That is, it enables the court in applying the test to any fact situation before it, any challenge legislation before it, to take account of how legislation operates in context. And that will be in the context of larger regulatory schemes, as well as the way that it plays out in practice. And that's a strength that it gives the court the capacity to be flexible and to take account of all the context, but it also makes it difficult to predict the outcome with much certainty. Okay. And in this circumstance, I think it is multiplied by the complexity of these provisions and also their relationship with other provisions. Okay. However, even with that caveat, that I think it's difficult to predict how this will play out, I think there's possible to point to some real weaknesses. And just before I do, could I note, I think the difficulty in working out how a proportionality analysis is likely to be applied in these circumstances actually has been compounded further by the very constricted legislative and deliberative process around this. We do not have the benefit of deliberation and inquiries that might have given us some better idea of how this is likely to work in practice. So the very truncation of that process, I think, is part of the problem in trying to work out how this will play out in practice. But, and I will pick up on some matters mentioned by Catherine in her excellent analysis of the law, let me say the following about donation caps. So it's notable that within the structure of large political parties, state and federal donations are not aggregated. So donors to big parties can still distribute large sums across different states and territories, since the federal and state and territory branches of registered political parties are considered to be separate political entities. And the provision of the law on which this turns is the nominated entity exception. The Act sets up, I think, drawing upon Victoria's electoral funding laws, the idea of a nominated entity, which is defined as an entity that has a certain relationship to a registered political party. So only registered political parties can have nominated entities. And the donation caps do not apply to transactions between political parties and their nominated entities. So that very much undermines the effectiveness of the donation caps in relation to political parties, but not in relation to candidates that are not affiliated with a political party. So that's the first thing to notice. Now, in relation to expenditure, we see the same kind of problem arise. We have a per electorate cap of $800,000 that may be spent by or on behalf of a candidate, but there is also a provision for non-targeted spending. And in relation to non-targeted spending, which is spending that might address a political party's agenda in general, but without being targeted towards a particular candidate, there is a federal cap of $90 million. So big parties that field candidates across Australia can diversify the $90 million and choose to spend little in safe seats and concentrate on marginal ones, so long as their electoral expenditure is not targeted at a specific electoral division. And I think that means political advertising which does not name or show the image of the local candidate or division. Okay, so this seems to create just quite a plain problem, that it will be enormously advantageous under this electoral scheme to be affiliated to a political party. And let me just reiterate, a nominated entity is defined by reference to a registered political party. So the distortion that this implements is reminiscent of the distortion that were found to be unconstitutional way back in 1992 in the Australian Capital Television case, in which a scheme that banned political advertising but then distributed free political airtime was found to be unconstitutional because the way in which that airtime was distributed favoured incumbents. That seems to me to be quite a compelling problem for the Commonwealth to overcome here. Now, with the benefit of time and, of course, its excellent legal advice, I'm sure the Commonwealth will have really good arguments to defend this law, but I find myself unable to summon them up here. I will note that there is a difference that I suspect it may be traded upon to try and save this law. So the inequality that was problematic in ACTV was between incumbents and new entrants. Okay, that was seemed to be distorting because it favoured keeping those who were in power in power. The kind of inequality here is different. In fact, there is some way you could say there's a false kind of equality. All candidates can, in theory, affiliate either with an existing party or maybe or register a new party and establish a nominated entity to take advantage of the nominated entity exception. But almost as soon as I state that, I think its weakness is evident. I think, first of all, that's not likely to occur in practice, given what I think would be the substantial organisational and material barriers to founding a nominated entity for some independents at least. And I think there are cases in which the High Court's been really, really attuned to how the law works in practice. I think the way Unions of New South Wales, for reasons that time doesn't allow me to detail, is a really good example of that. But secondly, I think, and this is perhaps the point on which I just want to end, there's at least an argument to say that it's not desirable that there be such strong incentives towards candidates organising to be part of political parties in our system. Okay. It is true that we have for a long time had a two-party dominated system, but there's at least an argument to say that the kind of representation offered by an independent is qualitatively different from the kind of representation offered by a candidate who is a member of a party, and that, consistently with our constitutional schemes, Australians ought at least to have a fair choice where they want to choose independence and the form of representation that they offer over representation by the member of a political party. Now, happily, I think this is a thought on which my colleague, Will Partlett, will expand. So in conclusion, let me say, there's something really dispiriting about the federal legislation, and particularly about what seems to be the cynicism that is involved in this hurried enactment. But there is a potential silver lining. We do have improvements in the disclosure requirements in particular, and it is possible that we would see a challenge to the donation and expenditure caps succeed and leave the disclosure requirements in place. And in doing so, the Australian courts, and particularly the High Court, would have the opportunity to address, and I hope to confirm, the importance of having an option for independent representation as a form of representation that deserves an equal chance amongst our electoral choices. Thanks.
Thank you, Adrienne, and for such a panopticon of the jurisprudential framework, but also where the vulnerabilities in this legislation might be. Of course, also a silver lining is always welcome in this area. So, Zim, I believe it's over to you to give us a bit more of the book and your comparative and theoretical insights.
Okay, thanks again for the introduction, Ros, and many thanks to Adrienne and the organisers of the Global Public Law Seminar Series, and to my other fellow panelists, Catherine and Will. Good to join you in this discussion, and thank you to the audience for their interest and engagement on these issues. So as we've been discussing, the federal political finance laws underwent significant change earlier this year. The changes included a lowering of the disclosure threshold, requirements for faster disclosure of donations, caps on donations and expenditure, among other changes. And there's much to be discussed regarding these reforms. And as Catherine and Adrienne have pointed out in their insightful analyses, these reforms raise a lot of interesting and important constitutional and practical questions, and indeed concerns. A lot of questions have been posed already. In what follows, I want to concentrate on one aspect of the reform, and that's what we might call the model public funding, so the arrangement of public funding, and make some observations about how it works and what might be considered reasonable alternative designs. The new law increases the amount of public funding payable per vote. Previously, it was $3.35 per vote. From the next election, it's scheduled to increase to $5 per vote. That's a sizable increase, nearly 50%. You might recall that some critics of the government and opposition, of course, they were together on this at the time, they zeroed in on this aspect. This formula applies to parties that secure 4% of first preference votes. A recent analysis by the Australia Institute suggests that about 75% of the money, public funding, would go to the big parties under this formula. And there's also new administrative funding for parties, and this works out at $7,500 per quarter for each member of the House, and half of that for each senator. And so the question that I really want to grapple with is this a good arrangement? In what sense might we evaluate this, assess its qualities? And here I want to turn to some recent normative work I've been doing with a colleague, Matteo Bonotti. He's a political theorist at Monash, and we've been trying to develop a framework for assessing political finance rules. And the framework is anchored in the contention that the purpose of political finance rules is to improve the functioning of democracies through political parties. In other words, a party democracy. It's not anti-independent. We can imagine parties of different sizes, and independents, if you like, lie at one end of that spectrum. And at the core of the framework are two dimensions along which political finance rules can be assessed and compared. These dimensions are linkage and collegiality. Linkage is the idea that parties, or representatives indeed, at their best, connect citizens to the state. They channel citizens' demands upward. We might call that voice. And they make elected representatives accountable downward. We might call that accountability. Collegiality is the idea that the parties in a party system are not only competitors, they're also collaborators in a grand project, and that grand project is the sustenance of liberal democratic institutions and the advancement of the common good. And that in turn imposes other demands such as civility in discourse, nonviolence, public justification. There are other requirements associated with collegiality. Now, in an ideal world, political finance should help linkage, and it should support collegiality. So those are the grounds in which we can begin to assess political financing rules and political financing arrangements across countries. And whenever we have these two dimensions in mind, we can begin to imagine various problems, or as we call them in the book, pathologies. And these can arise in both dimensions. So, for example, in many countries, perhaps including Australia, we see political party systems where the parties seem detached from the concerns of common citizens. And that is a deficit in the linkage dimension. So the linkage dimension is attenuated, it's not working so well, there's weaknesses in it, however we want to frame that. Or there might be a breakdown in civil discourse between party elites, that's a surfeit of collegiality. Or there might be too much coziness or clubbiness among party elites, that's, if you like, an excess of collegiality. So there can be excesses and surfeits, right? But there are problems that range roughly in these two dimensions. There's, of course, more that could be said, but not in the time that I have here. Yet even with this basic set of concepts, I think we can begin to make some sense of the direction of travel of the federal political financing system, the funding component, at least in a tentative way. So there are three changes I just want to zero in on. First of all, comparing the old model, so what existed status quo ante before the reforms, as of basically the system under which the last election was conducted, compared with the system under which the next election is scheduled to be conducted. Three changes to consider. First of all, compared to the old federal model, there is a marked increase in public funding along with spending caps. So we might expect a greater amount of total spending to come from the public purse. Now, more public funding, less private funding, we would expect to lead to an improvement in what we call linkage. And this is because of a well-known problem with uncapped private funding, which Catherine alluded to, which is the potential for large donors, sometimes known as fat cats, to capture the representative process, squeezing out the voice of ordinary citizens, and reducing that risk through public funding increases the quality of linkage across the system as a whole. Public funding is also associated with a collegiality gain because it curbs the so-called arms race of funding. That's the intense competition between parties for big money. Instead, parties don't need to compete on that front, and they can instead focus their competition on policy matters. The old system penalized new and small parties, but that hurdle has possibly gone up even further. The threshold for public funding remains at 4% of formal first preference votes. And because of the new changes, a rich backer can no longer overcome this due to donor caps, or at least it's much harder to do this. And in our framework, this results in a linkage loss. Why? Because there's a loss of voices speaking up for issues on which the main parties are silent. So at the margins of the system, the fringes of the party system, those voices, often independent voices, are struggling, will struggle more in this system. And if we think about the third aspect that I've highlighted here, administrative funding, I think the judgment here is a bit ambiguous. On the one hand, linkage could go up if these funds help representatives to connect more often and better with voters. So you can imagine if a lawmaker, a representative is doing more representing, more talking to constituents instead of doing administrative work in office, and which they can delegate, then that's perhaps a good thing for linkage. But on the other hand, linkage could go down if that admin funding in effect serves to insulate representatives from voters. And that's another way of expressing this pathology of cartelization that I alluded to earlier. So the overall verdict on the new system, having just highlighted these three aspects, is, I think, pretty ambiguous. Some gains alongside some losses. Is the new setup better than the old? I guess it largely depends on one's vantage point, but at best we can say marginally so. And then this raises the question, are there reforms that would be an unambiguous improvement in terms of linkage and collegiality? And I think the answer is yes, for sure. Even if we're working with the parameters that we've been talking about, linkage and collegiality could probably be improved by, for example, lowering the threshold for reimbursements, equalizing the administrative support for senators as compared with members of the House. The current formula favors members of the House, and of course the bigger parties tend to do better in the lower house than they do in the Senate, so that has a disproportionate impact across the party system. And such tinkering within the parameters of the existing system is important and could lead to real improvements in terms of linkage and collegiality. However, much of the debate has, I think, focused on such refinements of the existing model, this dollars per vote model, and the accompanying architecture. And what I'd like to do just briefly is to make the case for broadening the discussion to also think about other models of public funding, which I think have normatively attractive properties. And I want to flag three models in particular. The first is the voucher scheme, which the best exposition of this is by Bruce Ackerman and Ian Ayres in a book published in 2004 called Voting with Dollars. And in this voucher scheme, citizens are provided with coupons which operate like money in the political finance domain. So it's kind of like monopoly money, but really has real effects in political finance. You can't use it anywhere else, right? So you can't go shopping with your vouchers, but you can use them to fund candidates and parties. How much the vouchers are worth and how many vouchers a citizen receives, et cetera, these are questions that an institutional designer would need to address. But if we follow the design of the arrangement in Seattle, Washington, which has been using vouchers for a while, then each citizen gets 4 vouchers, each valued at $25, and there's no private funding allowed. Now, if we think about that model, citizens can decide which parties to distribute their vouchers to. And you can imagine a strong partisan might decide to give all 4 of their vouchers to their first preference party, right? So I vote for a party and I give it funding support through my 4 vouchers. But another kind of voter who's more conflicted or more strategic might give their vote to one of the major parties, but all of their vouchers to their favorite minor party. And their thinking might be rather different. I want to support my least despised major party to form government, but I want to financially support my most preferred minor party so that it can raise fringe issues that I care a lot about. And this kind of nuance in the expression of political preference should, I think, be quite intuitive to Australians, of course, because we're used to preferential voting. And imagine if the distribution of political funding in political finance also allowed voters to make the nuanced choices about the channeling of their share of public money. And this would be in stark contrast to the current system where the public money automatically follows your first preference vote. So it breaks that connection. So the voucher system has the benefits of public funding with this added expression component, which in our framework improves linkage. So that's one alternative. Another alternative is the matching system. And under a matching system, public funding follows private donations. For example, in the system used for US presidential nominations, so the competition before the parties produce their 2 presidential candidates, so the competition for that title, donors can give up to $250, and that's matched 1-for-1 by the public purse. The public purse could top up by a smaller or larger multiple. So in New York council elections, the multiple is 8. So a $10 donation is worth $90 to the candidate because the public purse chips in $80. So this doesn't eliminate private money in the way that the voucher system would, but it amplifies the effects of small donations. And particularly if this kind of multiple matching scheme exists alongside donation caps, it can transform a private system of financing from one in which there's a few fat cats paying for most of the election to a system that we might call one of kittens, where there's many small donations. And from a standpoint of linkage, this is much less problematic because you've got many small donations trying to shape the political financing market. So that's the matching system. It's a second alternative to the dollars per vote model. The third design I'd like to flag is one that exists only hypothetically at this point. It's developed in the book. It's also developed by other authors, but I don't know anywhere where it's been trialed. And we call it the anonymous donation scheme. And under this model, individuals can donate to parties, but they do so indirectly via the Electoral Commission. After some deadline, the Electoral Commission aggregates all the individual donations to each party and writes a big check to the party. And this model, if you sort of haven't quite got the intuition already, it allows for the kind of expression through money that supporters of private financing like to highlight. But it also addresses the main criticism of private financing, which is that the donations come with strings attached. If the donors are anonymous, then the recipients can't owe them anything, right? So the recipients, you don't know who's donated to you, right? So it's hard to do their bidding. And furthermore, the pool of donors will likely change from folks who do expect something for their dollars to a different kind of donor, those who are genuinely giving money to support a cause without the expectation of any favors in return. So how do these models compare to the current and previous funding models used at the federal level? My provisional judgment would be that they compare favorably in terms of linkage and collegiality. and in other words, moving toward these rarely discussed models might be useful. And that just leads me to a few concluding thoughts. The big point is that there are important design options out there about how to organize public funding, which are not well known in the Australian context, but which have desirable properties. And I've highlighted three, I think that there will be others, particularly if we begin to consider hybrids of these, or particular combinations of these different models. That's another innovation that's important. And by highlighting these options, I'm not saying that we should dispense with the prevailing model, but my contention is a more basic one. Whenever these moments of reform come up, we should consider all the sensible options, and those sensible options will oftentimes, I think, go beyond the prevailing models that we're used to. And I'll stop there. Thanks for your attention.
Thanks so much, Sim. Such interesting alternatives, and we'll be pressing you a little bit, no doubt, in Q&A on some of what the lessons are from Seattle and elsewhere. We do have 2 questions already in the Q&A, but if you'd like to add to that with your thoughts or questions, please go ahead. And now, last but certainly not least, in terms of our panelists presenting, Will Partlett. Thanks, Will.
Thanks, Ros. I want to pick up on a few things that both Adrienne and Zim have mentioned, particularly Adrienne, which is to talk about the potential constitutional importance of independent representatives in Parliament in the Australian tradition of representative and responsible government. So it's pretty clear, I think, from the way Catherine described these laws and the process in which they've been put through, the reaction in Parliament to them from community independents and crossbenchers, is, the impact of these, the functional impact of these laws will be significant for independents, i.e. members of parliaments who are not member of parliament, whether Victoria, Commonwealth, or wherever these laws exist, that are not members of major parties. It will have a significant impact on them. And the question is, why should we care? There's obviously some important, I think, constitutional reasons why we should care. Adrienne already mentioned and started to outline one of the reasons why we might be worried about this and its impact on our system of representative government in Australia, in the sense that the Australian system it would reduce the choice or the ability of individuals to make their case to the Australian people, particularly those who were not members of major parties. And in that tradition, we'd be thinking of significant structural kind of advantage to incumbency. And in this case, incumbency, not necessarily the party in government, but the parties that the two traditional parties, the Labor Party and the Coalition would have significant advantages because of their use of obviously the nominated entity exception. So, and this is a problem, and this is a deep problem. One that I found interesting quote from all the way back in 1874, which talks about there's a similar debate then. This debate has existed throughout Australian constitutional history, and there has long been arguments in this tradition for the importance of independence. One individual criticizing Henry Parkes for encouraging people to vote for major parties. In this case, the individual says that parties are problematic. Why? Because elected representatives are forced to vote against their conscience, and it distorts the view of constituents by forcing these members of major parties through the private and biased mangle of the closed party room. So there has long been a tradition in Australia pre-federation through the founding conventions and through into the idea of directly chosen by the people, of a value for a form of representation where we have what Zim, I think, was referring to when he talks about linkage, a really strong connection that we see between, say, a community, an independent, and their constituents, which in some cases can be obfuscated by a major party. So do we want, and is this something that we value in a system of representative democracy? Is this something that the court would potentially be wrestling with and thinking about as an intended idea of our representative democracy? To the extent to which the electoral reform bill itself is directly targeted at disadvantaging that form of representative relationship, and you know, the concerns that raises. How the Commonwealth will counter that argument is we remain to be seen. But that will be a strong argument, I think, that can be advanced on behalf of those challenging these laws, whether at the Victorian level already challenged or at the Commonwealth level a challenge coming, will be around representative democracy and its potential impacts or limitations on the directly chosen by the people requirement in Section 7 and 24. Second, we also see its impact on responsible government. Community independence or independents or crossbenchers, those outside the major parties, are quite important aspects of holding government accountable. We see this in a number of different ways. You know, that perhaps the most important, of course, part of Australia's kind of distinctive form of responsible government, one that was, when, you know, this was first crafted in the 1890s in the Australian constitutional order, where we don't know what's going to happen. We have an elected upper house that represents the states and a lower house that represents the people of the Commonwealth. How is this going to develop with relationship to responsible government? Will it break responsible government? How is it going to? There was a lot of, you know, I think at this stage there was an idea 120 years ago that this would develop over time. It has developed over time into the upper house having a significant tradition of having elected representatives who are independents, who play in critical roles on committees, on sitting or asking questions of the members of government in the upper house, or in even community independent or independents in the lower house, asking questions or holding accountable the executive government in a way that we see the major parties not doing as much. And so we can see numbers of different mechanisms whereby independents themselves kind of buttress or support these forms of representative, or in this case, responsible forms of government. As I said, question time. We saw in the Egan and Willis case a very important example where the upper house in New South Wales actually removed the member of the government from the upper house, the Legislative Council, for refusing to give documents about executive actions with respect to a mining issue. So the idea that the responsible government is in many cases protected or driven by independents or those who are sitting outside major parties, or acting in sometimes tandem with the opposition, sometimes on their own, in carrying out forms of robust forms of responsible government, holding the executive to account in a way that is so that responsible government in this context is more than just that the government commands the lower house, which of course, given the strength of party discipline, is always going to be the case, but that in this case that these independents play an important role in ensuring that. And as we've said before, sitting on parliamentary committees, we've seen, or chairing parliamentary committees, is something we've seen at the Victorian level, is the kind of the glimmerings of restoring parliamentary committees to having a really important role in holding the executive to account, is when you have independents or non-major parties representatives sitting and chairing committees. We see this now with the Integrity and Oversight Committee in Victoria, which is headed up by Tim Reid, a member of the Greens Party, which is, I think, in many ways starting to reassert a role for the committee structure in holding and using its powers and its representation of the broader parliament and also the broader public in holding the executive to account through forms of committee oversight, committee transparency, and so forth. So in that regard, we can see, I think, in important ways that the laws are in targeting and particularly in disadvantaging new entrants who do not choose to become parts of major parties or members of major parties. In disadvantaging those candidates, it actually can, and I think the court would potentially take account of its impact and its potentially problematic impact on the functioning of Australian representative and responsible government. And of course, we await the arguments from the relevant, whether it's the Victorian government or the Commonwealth, in respect to any challenges, the challenges that exist or that are coming. But I do think those will be critical ways in which these cases are going to kind of develop over time, and we're going to see the kind of the arguments emerge. How is this going to be justified as something that is reasonably adapted and appropriate to a legitimate purpose, right, that is consistent with representative and responsible government? And we're just going to have to wait and see how that plays out. But it will be, I think, important, and particularly, the final thing I want to say is the process concerns that both Catherine and Adrienne raise are a significant concern here, because it is not clear to me where and why the government, or in this case the Parliament, when it passed these laws, both at the Victorian level and at the particular Commonwealth level, what were they thinking? What was their justification for introducing this disparity, and for disadvantaging any new entrant who is a community independent or a member of a non-major party who is going to struggle to be able to speak and to be able to reach and link with voters in the future? How is that to be justified? There's going to be less of a record, I think, for that case to be made when these cases, or one case, and I likely think a future cases coming as well, when the High Court considers these cases. So I'll stop there.
That's very helpful, and brings us right back to where Catherine started, both as to the impact on different categories of candidate, and also the process. So we have two very interesting questions in the chat. Before we turn to those, I did want to just ask our panelists to think a little bit about how they would think about certain aspects, and I'm going to come back to these questions. So if you just want to make a note of them, we'll go to our online questions first. I think one of the things I'd be interested in about the Seattle model is whether the sort of paying to encourage parties has been seen as in any way encouraging a kind of buying of influence model, whether there are concerns around integrity being worsened rather than improved in Seattle. It's hard to tell because it's one of the more honest states in the United States, but how people have thought about the kind of buying your party as having that more corrosive effect compared to, say, the matching style models. I think someone said about the 4% level being one that translates. I think this might have been using to 75% of the spend on major parties. But I wondered if any of the panel were aware of modelling about where, if you move that threshold up or down, say down to a 3% threshold or a 2% threshold, how that would vary in terms of what parties and what level of distribution. And I think one of the things that would also be useful for all three of the sort of more politically focused comments, as well as Adrienne in terms of constitutionality, would be to reflect on what our landscape currently is in party terms, which is we have such an unbalanced election result. To talk about sort of collaboration, I guess, between two major parties seems something of a sort of outmoded way of describing things in 2025. And so I wondered whether we could think through how not only the independents, but also the very large number of minor parties that contested the last election, some of which did very poorly and some moderately well, how they would be impacted by this landscape, both conceptually and empirically. So then turning to the more specific questions online, we have two, I think that would be for you, Adrienne, about Babette and the Commonwealth, and then a question from Anne Toomey about unions number 2. I'm going to read both of those to you, and then I'm going to ask you, Catherine, whether you think it's possible to answer the first question, which is a very interesting one about retrospectivity. So the questions, I think, for Adrienne are, and of course anyone else could answer it if they wanted to, what they think the implications of the recent decision of the High Court in Gilbert against Commonwealth are for the application of a test of structured proportionality in this context. And the second question from Anne is about whether you think this legislation is consistent with the court's reasoning in the Second Union's decision in terms of legitimacy of purpose, because of course your remarks suggested that the purpose should be considered legitimate, and Anne is questioning whether there's sufficient, if you like, basis for that in terms of the corruption rationale. So over to you, Adrienne, first, then to Catherine, and then the panel on my questions.
Okay, so first of all, let me take Anne Toomey's question, and let me just acknowledge how wonderful it is to have Anne Toomey as part of this webinar. Of course, she's an enormous expert on these questions. So my response to your question, Anne, is as follows. Yes, I accept one way that you might analyse the failures of the federal legislation is to say, when you actually look at it as a whole, given the many deficiencies that Catherine's outlined and the problems that I've outlined, to say, we don't actually really think that this is directed towards a legitimate end. Actually, the failures, you might not actually say this quite out loud, but let me say the quiet bit out loud. Maybe it reveals what this is actually about is entrenching the parties, an agreement between the major parties to entrench themselves and to fend off the recent challenge from independence, right? So you could analyse that and say, and in which case, the way you would apply the test is to say this law cannot really properly be said to have a legitimate end. Alternatively, you could say those failures indicate that if it does have a legitimate end, it's not properly directed towards them for various reasons. The same facts lend themselves quite well to either form of analysis, and that's actually a feature of proportionality analysis, is that its various categories can be applied to the same facts. I have no difficulty in analysing it either way. Okay, now I answered that question first. And so actually, let me just say, so Anne, you could be absolutely right. As in Unions of New South Wales, where the provisions that required parties associated with industrial organisations to aggregate funding for the purposes of the application of the caps, the court said, we just don't think that they can be understood as directed towards a legitimate end, not actually saying what we might have thought, which is this appears to be an attempt to disadvantage one side of politics. So you could analyse it that way. You could analyse it the way I accept that I have analysed it. The facts lend themselves to either conclusion. Now, I answered that first because that takes me to the second question. So I've been talking about the proportionality test, which is an element of this legal test. And somebody's asked, I think, in a very timely fashion about the High Court's recent decision in Babbitt. I don't want to go on for too long about it. Let me just say the following things. Babbitt reveals that this long-standing division among members of the court about the application of proportionality analysis, which we might have thought had been resolved by a number of majority decisions, for example, in Club, is still percolating. And what I suppose is interesting about it is you have Justice Jago, whose views we didn't clearly have before, joining with Justice Gagler in a judgment that expresses some scepticism about proportionality analysis. But I will note that both those joint reasons and the separate reasons of Justice Gordon that express this scepticism don't explicitly find that it's an improper form of analysis. They say it's an analytical tool. It just may or may not be helpful. On the other hand, you have Justices Edelman and Stewart emphatically insisting that proportionality analysis in its structured form is to be continued with. And then you have the judgment of Justice Gleeson, which I think comes to the position that is closest to the one that I hold. And I hope that I'm not putting words into the mouth of Rosalind Dixon when I say I think it's close to views that Rosalind has expressed. We both have pieces in volume 48 of the Federal Law, if you want to follow them up, that express this. And so my view would be, in a sense, we don't have to worry too much about this, because every conceptual step in structured proportionality analysis is part of the preferred form of analysis adopted by the other judges. And so whichever one you adopt, it gives rise to the same form of analysis. And that's perhaps why the question of whether you do or don't adopt structured proportionality analysis appears to have no impact on the outcome. So I note the continuation of this rather long-running dispute, but I'm sceptical about whether we need to worry too much about it, given I think the conceptual equivalence or near equivalence of the two tests.
Thank you, Adrienne. So we have two questions now for you, Catherine. One is about whether the sort of prospectivity, retrospectivity concern in relation to the major parties and planning provides a persuasive justification for the nominated entity exception and its scale. And another question about whether you think, in light of the scale of spending for some of the TILs, there should be no expenditure cap at electorate level, or if there should be, what it should be in order to accommodate the very high levels of spend by those independents in order, they would say, to compete against the major parties in those very competitive seats. If we could ask you to talk about that a little bit, Catherine, that'd be great.
Yeah, great, thank you. So on the nominated entity question first, I suppose, to be frank, I don't make much of that argument that, or even if it were, and of course it's arguable, but if it were true that this abolishing the nominated entity exemption would disadvantage those past financial decisions, it would mean that we should have a nominated entity exemption. I would disagree with that view, because what we know, we've now seen the consequences of the presence of the nominated entity exemption in Victorian law. And again, Victoria is different from the other jurisdictions where a nominated entity exemption exists, because it exists in the absence of an expenditure cap, and the way that the provisions operate mean that they advantage parties that had nominated entities prior to 2018. So particular circumstances. But we've now been through an electoral cycle where they exist, and we have no longer any independence in Victorian Parliament. So it is, and when you talk, and of course the evidence is anecdotal, when you talk with them, the experience that they had was that raising donations up to the low donations threshold in Victoria is hard for independent candidates, and it is hard in particular for non-established independent candidates. And you have to raise, of course, however many of those $4,000 over an electoral cycle, more or less lots you can raise, determines how much you're able to spend, versus parties that have a much better fundraising capacity to begin with. We know that the structural advantages in respect of fundraising, and the fact that they've got nominated entities who can donate to them outside of the cap structure has meant, it seems to us, that non-major party candidates have found it really impossible to compete. We saw too in the Victorian independent expert panel report that was provided to the Victorian Parliament back in early 2024, I think. Now, on that panel, we had the former Electoral Commissioner in Victoria, Liz Williams. We also had David Feeney, formerly with the Labor Party, and Helen Kroger, former Liberal Party person, make a series of recommendations. And one of the recommendations that a majority of that panel, which the majority was in this case Elizabeth Williams and David Feeney, recommend the abolition of nominated entities because of the inequality that they produce. So my view from a policy perspective, and it's not a constitutional perspective, it is a policy perspective, is that even if it could be argued that it would disadvantage those past financial decisions, the abolition of the nominated entity exception would remedy really serious inequality that exists now in the electoral system in Victoria, and that, in my view, will also exist in the federal system as a consequence of the inclusion of the nominated entity exemption there. And when on the point about whether it would be mitigated by having the nominated entity exemption phase out over time, look, I'm really not sure. I'm not sure how long you'd need it to phase out over in order for it to be mitigated, and whether it would be justifiable, when ultimately our concern has to be about the equality of all players to participate in the electoral system, not the equality of legacy parties that had significant assets from in the case of the McCormick Foundation, sale of a radio station a long time ago. So that's my view on that point. The view on the other point, which I'm just trying to see what it was a really good question, and now I need to recall it. It's about,
what would your optimal cap be in a single electorate, or would there be no cap? I mean, obviously equalising by getting rid of nominated entities was part of your answer, so perhaps that's where you want to leave it, but if you wanted to add anything.
No, I do have other recommendations to make, and so these other recommendations that I'm going to make are recommendations that are the view of the Centre for Public Integrity, as well as the Australia Institute, as well as Transparency International, and also the Australian Democracy Network, because we hoped that there may be in the new Parliament an opportunity to try to remedy the worst aspects of the federal legislation that was passed. And so we've done some thinking about this. Now, in our view, the best thing to do with working with the architecture of the existing legislation would be to lift the per seat spending cap up to $1.2 million, and to lower the nationwide spending cap to around $60 million. And we settled on that because obviously you could try to fix it via really making sure that there cannot be flooding of key races with enormous amounts of non-targeted expenditure. So we think that it's extremely complex, difficult to implement, and therefore the preferable path would be to just lift the per seat cap to $1.2 million and lower the overall nationwide spending cap. That's our view. I don't think we would not want to see the entire removal of an expenditure cap. We think that it can be done well. We think that it's been done well in New South Wales, and that with the willingness across the Parliament to engage in the process in a way that is about the best democratic for the outcome for the country, you can get there and have an expenditure cap regime that works. We didn't get there in this case, in my view.
Thank you, Catherine. Will or Wasim, did you want to add anything either generally or in response to the prompt I gave you?
Yeah, just to come in on just very briefly to talk a little bit about what type of, I mean, I think a lot of the discussion around these electoral laws, at least in my view, is a discussion around what type of form of parliamentary representation and parliamentary accountability we want to have in Australia. The electoral reform laws themselves envision a highly centralized conception, right, of legacy, essentially based around legacy parties dominating both Parliament and dominating our form of representation. And we've seen quite a lot of quite well-funded media campaigns to try to support that form of representation, right? It's stable, it's efficient, you get stuff through Parliament, you don't have to deal with minority governments, it's not, blah, blah, blah. Now, we've heard that argument. I do think it is worth considering and thinking about the importance of what role that minor parties or even independents play, new entrants play into the system of both ensuring better forms of representation and better forms of responsible government and accountability. Catherine mentioned in Victoria with these laws, we don't have a single independent or community independent or independent in the lower house now in the Legislative Assembly in Victoria.
Mm-hmm.
That's significant, right? That has changed the nature of debate in the lower house. It has also meant that individuals who were meant to sit on parliamentary committees, right, who joined parliamentary committees, they're no longer there to sit on those joint parliamentary committees and provide a kind of more independent voice that's not subject to party whipping. And finally, the second is to think about how they relatedly how they hold the government accountable, how they hold the executive branch accountable so it's a different form of representative and responsible government that's being envisioned. And is this one that we really, really want? Hopefully the High Court will step in. If it does not, then hopefully we as Australians will elect a new government who will rethink these laws, because I do think they take a particular conception of democracy, which is I don't find particularly attractive, and that is one that kind of is less able to provide representation or accountability in the kind of tradition that we have had in the Australian context for quite a while.
Thanks, Will. And I mean, I think one of the really interesting things also that's raised by the trumpet of the Patriots relaunch is how hard it is to come up with any kind of tight exception which allows for disruption in, say, one election where people might not be subject to caps once and then be subject to them, because, of course, there were very many interesting electoral issues around that. Zim, perhaps the final word?
Oh, thanks a lot, Ros. I'm just going to address your really interesting prompts. So firstly, Seattle, there's been some really interesting empirical testing of the effects of vouchers in that context. And one of the findings is that the voucher scheme is actually very popular. And if we're thinking about Catherine's idea about political finance and public trust, this being an important connection, then the voucher scheme seems to be something we should be taking a very serious look at, because the studies do suggest that it can be very good for not only public trust, but actually the diversity of candidates who stand for election. So we end up with more diverse candidate pools whenever vouchers are used. So the tentative evidence suggests. On your second prompt about modeling of reducing the threshold, I'm not aware of any modeling that's looked particularly at that. One would expect that if the threshold were lowered, that the major parties would receive relatively less, right? So that 70% would go down. Now, I think there's an interesting question which Will zeroed in on about much of this debate being about what kind of representation we want. I think this is a really, really important question. It's a question on which Australians disagree. And I think this is important to bear in mind. I think, there is value pluralism in this space. People disagree about what their idealized party system ought to look like. And there are important arguments in various directions. For what it's worth, I think that you probably don't want a threshold at zero, because I think that, in forums like this, we tend to be very critical of parties. And I think, just to play devil's advocate a little, there are important things that parties do, and there's also important benefits to some concentration, and there are important risks of hyperfragmentation. So what we do want is an important balance. I mean, I think the problem with 4%, and it's 4% of first preference formal votes nationwide, and whenever you add up all those little conditions, that's actually quite a high bar. And if you lower the bar a little bit, I think you might get, a little bit more voice in important ways that matters. And I would add also that, one of my concerns about 4% of formal votes cast is that it makes it very difficult for proto-parties, potential parties, ideas that could become parties to emerge. If there's a way of demonstrating, for example, that you've got nationwide support, but that hasn't crystallized an organization yet. Imagine if you could demonstrate that with polling or some other way of signaling signatures or some other way of showing support. I think that would be valuable to append alongside votes. So I think there should be multiple ways of showing that you represent community support, that you represent a community idea. So a body of voters is one way of doing that. Maybe there should be other ways that you can show that you represent an important community that should be represented in the Australian Parliament. And finally, what is our landscape in the current climate? I think this is a great question, and in fact, it's if you like, the question that was on my mind whenever Adrienne kind of invited us to participate in this event, because we are all perhaps expecting a slightly different election result, and we are imagining that the landscape for reform in this area might be more conducive. That might have been the case if, for example, There was a hung parliament, which of course didn't happen. All of that's to say that you know, we should be thinking about both the impact of the reforms on party systems, but also the way in which party politics and electoral outcomes shape the political opportunity for future reforms. You know, because the reality is that a thumping Labour majority, the sorts of reforms that are on the table, the set of feasible options looks rather different than if the Teals and other independents held the balance of power in this hypothetical parliament that didn't actually transpire. So I think that there's interesting questions about what the set of feasible options might be going forward for this term and potentially for future terms.
Well, a great place to end, which is, you know, the rules of the game determine the players who determine the rules of the game, which is, of course, the great challenge of this area of regulation. I just want to note how many distinguished people on the call have great expertise in this area, and it was so wonderful to have them join us this evening. But of course, the greatest thanks, particularly tonight, go to our 4 expert panelists. Please join me in thanking them if there's a reaction button that allows you to do so. And otherwise, on behalf of the CCCS and the Electoral Regulation Network and the Gilbert and Tobin Centre, thank you so much for joining us. We're very grateful for the opportunity to engage in this discussion on such an important topic. And thank you again to our panelists.